I am ready.
Okay, so good morning. It's Friday, February 18th, 11:05 a.m. We have we're going to be finishing up the morning session in the next about 20 minutes before we go to the floor. Just wanted to look back at some language from an earlier bill with another formulation on how to address forest blocks and forest fragmentation and habitat corridors. So Ms. Chakowski, the floor is yours. If you could share your screen, we'll follow along.
Sure. So I provided the committee with a PowerPoint presentation on February 1st. And so I'm going to put it up on the screen, and hopefully at some point Jude can post it for today as well, because we did start talking about it on February 1st, but we didn't get very far into it. So I'll put it up on the screen in the meantime, but this document should look familiar to you. Okay, can you see a chart?
Yes, ma'am.
So I'll start by further framing this conversation by saying, while the bill has been discussed in your committee, the chair asked me if there were other examples of ways in which the forest block language that you're considering for Act 250, what are other versions of it that have been considered, or what are some other options that could be considered? And so this discussion about adding forest blocks to Act 250 as a criteria has been around for quite a while, and the most memorable or the most talked about bill to do this work was H233 of 2017. That predates my time in the legislature. I did not draft it. I do think this committee looked at it potentially at that time. So that bill, as introduced, had some pretty strong language regarding forest protection. And I do have that language in these slides. That bill started in the House and was worked on by the House Natural Resources Committee, and they amended the language. And so the version that passed the House and then was committed to this committee in 2017 has different language than as was introduced. And so I've included that language in here as well. There was also a few different proposals considered in H926, which is the last big Act 250 bill that this committee considered, and that was in 2020. So there were a couple of different versions of language in that bill. So those are also in this slide presentation. But to start, I have this sort of side-by-side chart on the first page, and on the right side is the language that is currently in your bill, and I've lined it up on the left side with the language from H233 as introduced. So there are some similarities, but there are also some differences. So both bills do add new Act 250 definitions to be used in the new criteria. Both bills add new jurisdictional triggers to Act 250 in addition to new criteria that could potentially go with these, assist in further forest protection potentially. So in your bill, you currently have the road rule. In H233, there were two jurisdictional triggers that were considered, and they were different. I do have the language later in the slide, but just to introduce them, there was a new jurisdictional trigger that would require an Act 250 permit for any development that was more than 350 feet within, that was proposing construction within a high priority forest block. So high priority forest blocks would be mapped, and then anyone proposing development construction within a high priority forest block would trigger Act 250. In addition, it also amended the subdivision jurisdictional threshold, and then said that, again, if subdivisions were proposed in a high priority forest block, 6 lots would trigger Act 250 if the town had zoning, or if the town did not have zoning, subdivision of 3 or more lots would trigger Act 250. And so that would change the current threshold, which is 10 lots in a town with zoning or 6 lots in a town without zoning. So, and then your bill has this new sub-criterion we just talked about earlier, 8C. It's an undue adverse impact on forest blocks and connecting habitat. H233 had, it was adding 2 new criteria that were specific. So 8B was specific to forest blocks and 8C was specific to habitat connectors. H233 also did shift the burden of persuasion under the new sub-criteria from the opponent to the applicant. It also did put a new statute in Act 250 establishing the procedure for how an applicant would mitigate fragmentation of forest blocks and connecting habitats or habitat connectors. And then the last 2 provisions are very similar to the ones you adopted, so that you have in your S234. So there's requirements for rules for guidance for applicants to use the new forest block and connecting habitat criteria. Yours is also directing that NRB work with ANR to create rules for 8C. Okay. And finally, both bills require that ANR update their maps to include forest blocks.
The burden of persuasion for new sub-criteria falls to the applicant in 233. What's the status of burden of proof under 8C in our bill? Who needs to demonstrate that it's
a great question. So, and this may be an oversight on my part. So currently, the statute reads, so currently, 10 VSA 6088 establishes the burden of persuasion required for each of the criteria of Act 250. So currently, the statute says Criterion 8 is on the opponent. So it is not specific to your new sub-criteria. So I do think it would probably, it's implied that it also would be, as part of 8, would be on an opponent.
Right. And if I'm remembering our discussion about why we had such a provision, burden of proof falling to the applicant on this, was that it is difficult for an opponent to make this sort of assessment. They might not even be granted access to the property, etc. So the burden of proof was switched in order to have the applicant affirm that they're meeting. Anyway, so I'm just noting, resurrecting that earlier conversation.
Right, that's something to consider that this committee hasn't talked about recently. So, yeah.
Okay. Anyway, I don't want to slow us down too much because we only have about 15 minutes. But
all right. So your new language here, as we talked about before, would be added to Act 250 and would require an applicant not result in an undue adverse impact on forest blocks and connecting habitat. If a project would result in an undue adverse impact, a permit may only be granted if the effects are avoided, minimized, and mitigated in accordance with rules adopted by the board. So it's using this avoid, minimize, mitigate impacts on forest blocks and connecting habitat. And it does reference that there will be rules addressing this adopted by the NRB.
Okay, thank you.
And so here is the rulemaking language that's currently in your bill specific to this. So the Natural Resources Board, in consultation with ANR, shall adopt rules for this new Criterion 8C. The rules shall include how forest blocks and connecting habitat are further defined, including their size, location, and function, which may include information that will be available to the public to determine where forest blocks and connecting habitat are located, or advisory mapping resources, how they will be available, how they will be made available, how they will be used, and how they will be updated. So that's one of the first big questions. And House Natural Resources, when they were considering this 2 years ago, spent a lot of time discussing whether or not and how maps showing forest blocks would be used in the Act 250 process. Next, standards establishing how impacts can be avoided, minimized, and mitigated, including how fragmentation of forest blocks or connecting habitat is avoided or minimized, which may include steps to promote proactive site design of buildings, roadways and driveways, utility location, and location relative to existing features such as roads, tree lines, and fence lines. The rule shall include criteria to identify when a forest block or connecting habitat is eligible for mitigation. It will include standards for how impacts to forest block or connecting habitat may be mitigated. Standards may include appropriate ratios for compensation, appropriate forms of compensation such as conservation easements, fee interests in land, and other forms of compensation, and appropriate uses of on-site and off-site mitigation. And so this is somewhat similar to currently how the primary agricultural soil criteria works, where mitigation is an option if reduction in soil cannot be avoided or minimized. And there is a statute, section 6094, which lays out the exact ratios for calculating how mitigation is, when mitigation is used, how it's used, and what the ratios are. So H233 had all of this, or much of this in statute, but this is directing that these elements be looked at as part of the rulemaking. And so it directs the board to convene a working group to work on the rules on or before February 1, 2023. And the board shall file proposed rules with LCAR on or before June 15th, 2023. And I feel like those dates, I guess they make sense. But so that is actually giving the NRB a full year before they have to start the working group.
Okay. Let's, if there are no committee questions, let's go on to the next one. Thank you.
So I did want to point out a small option here. H926 that you received from the House in 2020 had a small difference in its version of HC. Currently, under existing Act 250 statutes, the Criterion 8 includes rare or irreplaceable natural areas. And so the House added it to the new 8C because it seems like a similar concept to forest blocks and connecting habitat. So rare and irreplaceable natural areas is already part of Act 250. It's just including it in the forest block and connecting habitat criteria, just moving it.
Okay. Structurally, if it's in 8, does it not automatically apply to 8C, or do you need structurally to have it made explicit?
So there are 10 criteria of Act 250, but each of the criterion has sub-criteria. So no, you don't need to move it. It's already part of Act 250. This isn't going, your bill wouldn't remove it or change it, but they just thought that it fit logically within the new criterion that was being established. So
Okay.
it's moving an existing criteria to a different part.
Okay, so I'll have to look at something bigger than the fragment. I'm personally I mean, let me check in with the committee. I would think you want to avoid undue adverse impacts would kind of course, include rare and irreplaceable natural areas. So if it's duplicative or anything like that, that seems fine by me that you would include it in the forest blocks. Anyone else have an opinion on that? So then I would say, let's expand the phrase to include rare and irreplaceable natural areas. Please, thank you. If we can't agree to protect those, then we're really in trouble.
Right. So this already exists. It's just being moved. That's
Yes.
clear, right? Okay.
Yep.
Okay. So I'm moving back. This slide presentation moves backwards in time. So before that, the bill as introduced, and so the bill that was contemplated by the Commission on Act 250 the next 50 years, there was language creating the two separate criteria, 8B for forest blocks and 8C for connecting habitat. The language is very similar to the language in H233. It had a couple of just small changes, but it is a little bit different again. And so I did want to point out that, so one of the changes is that this new criterion would say that a permit will not be granted for a development or subdivision within or partially within a forest block unless it goes through a avoid, minimize, mitigate standard, which is looking at whether or not it will avoid fragmentation of the forest block, whether or not it's feasible to minimize fragmentation of the forest block, and if it's not feasible to avoid or minimize fragmentation, then the applicant has the ability to mitigate fragmentation of the forest block using the formula in the new section that's proposed 6094. It then goes on to provide some information on methods for avoiding or minimizing the fragmentation of the forest block. And the language here should look very familiar because it is very close to the language I just read you in your rulemaking section in S234. So what your language in S234 on rulemaking basically takes most of this language and just puts it in a rulemaking section. So that's sort of how your rulemaking section originated. It was the language that was proposed in H233, then modified by the Commission on Act 250, and now it appears in your bill as rulemaking.
So maybe so one of the things I'm noticing that is different is this within or partially within criterion. And I guess, need to learn a little more. I mean, I can imagine that someone would say, well, the entire development doesn't occur within a forest block. There's, I don't know if a meadow within a forest then is considered not part of the forest block because it's a meadow. And you might want to look at it more holistically and say partial within or partially within, because the project includes the meadow and the forest or something like that. Does anyone else have that same reaction? Would anyone else welcome the modifying the phrase so that we are a little more, I don't know what to say, inclusive and organic? So,
towards what goal, Mr. Chair?
Well, so it's saying if the development is within or partially within a forest block, and knowing our landscape, it's easy for me to imagine places where you might start out with a roadside meadow And then you would cross that meadow and you'd be up into the forest block. But if someone's going to say the project's not entirely within a forest block and therefore it shouldn't be addressed, I would hate to have something not be considered because it wasn't just forest block that was being developed.
So
I don't know if that's what this implies.
So this is this is the language from the prior bill. This is not the exact language that appears in your bill.
Yeah.
So that, as it's currently drafted, your bill is actually asking if a development or subdivision will impact a forest block. It doesn't use the phrase within or partially within.
All right. So then we're set. Thank you.
Well, that's the difference. Yeah.
Okay.
Thanks, Alan.
Great. So let's go on to one more page, and then I think we're going to have to adjourn.
And so related to that, the original version of H233 as introduced, related to what we were just talking about, had a couple of slight differences. It was asking if the development or subdivision was going to be located on or adjacent to a tract that contained a forest block or connecting or habitat connectivity area. The 8C language has changed, the phrase habitat has changed a few times, but so this is again looking at a slight difference in how the project should be looked at on the tract. So this is looking at located on or adjacent to a forest block as opposed to within or partially within. And so these are pretty subtle nuances. I feel like I'm confusing the situation, but these were the options that
Right.
prior legislatures have considered.
Okay. Well, thank you. I mean, I'd asked you to assemble them, like so we could see how it's been described before. And if there's like just one more slide for this criterion or two, maybe we have a chance to look. It's 11:27. Then we'll have to adjourn and head out. Oh, standards of review. Okay.
Right. So no, I mean, this could go on for quite a while. This is a conversation that does have a lot of nuance to it. I did provide you with just some information about the different standards of review that are used in your bill versus that of 233. So 233 was including the avoid, minimize, mitigate standard, specifically about avoiding, minimizing, and mitigating fragmentation. Your bill is phrased differently. It's looking at an undue adverse impact on forest blocks and connecting habitat. And so that is different. It's a two-step process under Act 250 for looking at undue and then adverse impact.
Okay. All right. Well, thank you very much for helping us. And this is probably a perfect spot to pause for today. So thank you, committee, for making a way through a lot of information related to 234. I will be making an appointment with council to present a next draft of the bill based on our conversations. The novel section will be this ARPA funded housing and designated areas proposal. But otherwise, it's smaller adjustments, I think, based on today's discussion, which were very helpful. And I appreciate everyone